Hey, What Next listener. Before we start the show, I want to let you know about a story coming up a little bit later. It's from one of our partners, SAP. AI comes at you fast. If you don't get reliable and relevant advice, your business might miss out. Whether you're looking to automate tasks or embed AI in your business processes, SAP can help. To learn more, head to sap.com/AI and stick around for expert advice on how to embrace AI with confidence.
This is the story of the one. As head of maintenance at a concert hall, he knows the show must always go on. That's why he works behind the scenes, ensuring every light is working, the HVAC is humming, and his facility shines. With Grainger's supplies and solutions for every challenge he faces, plus 24/7 customer support, his venue never misses a beat. Call quickgrainger.com or just stop by. Grainger, for the ones who get it done.
If you are wondering what to make of the final day of Supreme Court decisions, which included a long-awaited ruling on whether Donald Trump's presidency makes him immune from criminal prosecution, Rick Hasen is here with some straight talk for you.
I can't imagine the court doing a better job for Donald Trump than what they did in this case.
Rick is a lawyer who writes for Slate. And to be clear, he never had a whole lot of hope that the Supreme Court would rule the way he thought they should here.
I'm not surprised, given how the Supreme Court has slow-walked this case, but it is even worse than I expected that it was going to be.
The basics are this. The court said presidents like Trump have substantial immunity from prosecution for crimes committed while in office. This includes absolute immunity for core constitutional duties and presumptive immunity for duties that are within the outer perimeter of official responsibility. That leaves an unspecified number of unofficial actions that actually can be prosecuted. Determining the line between official and unofficial, though, that requires an extensive fact-finding process. So imagine you're Jack Smith, the special counsel prosecuting Trump for trying to overturn the 2020 election. All of your evidence must now be reconsidered. Is it official? Is it not?
And so those of us who were thinking there's a glimmer of hope that this case could go to trial, that is now completely dashed. There is no way this case is coming close to trial. But like at least another year if Trump loses the election. If he wins, the case is going to be just killed, and that'll be it.
Some people, including the dissenting justices here, argued that this decision essentially creates a president who's actually a king. Do you agree with that take?
That language is in both the dissenting opinion of Justice Sotomayor as well as the dissenting opinion of Justice Jackson. I think it's only slightly hyperbolic to say the immunity is king-like. It is, in practical terms, going to be extremely difficult to go after a president for criminal liability for things that that president might do in office.
Today on the show, the Supreme Court's immunity decision is a huge win for Trump. It also fundamentally alters how our democracy works. I'm Mary Harris. You're listening to What Next? Stick around.
This podcast is brought to you by Slate Studios and SAP. AI is moving so fast. If you don't get reliable and relevant advice, your business might miss out. Welcome to Dear Artie, an advice column from SAP, where we tackle the tricky questions at the intersection of AI and business. Let's meet our expert.
Hi, I'm Ian Khan. I'm a technology futurist, speaker, and author, and I love to help organizations measure their current state of readiness for an AI-driven world. I'm excited to dive into today's question.
Dear Artie, our finance team is top-notch, but small. How can AI support them? Signed, Financially Drained.
Well, financially drained. A lot is happening in finance and AI, and the possibilities are endless. First of all, AI can help your finance team analyze massive amounts of financial data faster than any human or a team of people could do. Second, it can help perform functions on data through algorithms. This can connect different systems together and really simplify decision-making for your finance team. And last but not least, AI can help reduce the time needed for data to provide insights so that your leaders can make faster decisions.
Embrace AI with confidence. Head to sap.com/AI to learn more.
This episode is brought to you by Washington Wise. Decisions made in Washington affect your portfolio every day. But what policy changes should investors be watching? Listen to Washington Wise, an original podcast for investors from Charles Schwab, to hear stories making news right now. Host Mike Townsend, Charles Schwab's managing director for legislative and regulatory affairs, takes a nonpartisan look at the stories that matter most to investors, including the policy initiatives for retirement savings, taxes and trade, inflation fears, the Federal Reserve, and how regulatory developments can affect companies, sectors, and even the entire market. Mike and his guests offer their perspective on how policy changes could affect what you do with your portfolio. Download the latest episode and follow at schwab.com/WashingtonWise or wherever you listen. Can you remind people just how this case reached the Supreme Court? This ruling was about Jack Smith's prosecution of Donald Trump for his actions on January 6th. What were Trump's lawyers arguing here?
So first, I should say it was broader than January 6th itself. It was about the entire scheme to try to subvert the election. This included trying to get state legislatures to come up with alternative slates of electors and trying to get the United States Department of Justice to say that there was fraud in Georgia and other states that could again provide the predicate for throwing out the election results. So it was a whole course of conduct. And the claim was that this conduct violated different laws that prevent defrauding the United States, laws that prevent depriving voters of their rights to have their votes counted, and laws that prevent obstructing an official proceeding.
So that was the basis. But Trump's lawyers said, actually, all of these things I was doing, I was president, so it doesn't matter that I did them.
Right. So there's always been some level of civil immunity for official acts as president. So you don't like the war in Iraq? You sue George W. Bush. Courts say you can't sue Bush. You can sue a president for private acts, like Bill Clinton was sued for private conduct in relation to Paula Jones, and there's no immunity there. What we hadn't had before was, what about immunity from criminal prosecution?
So it was the first time we had to really decide this.
Mercifully, yes, because so far as we know, most presidents were not engaged in crimes when they were president.
Famously, Trump's lawyers made this argument in court a couple of times that the president, just by being president, should enjoy broad immunity from prosecution, even if he or she had asked SEAL Team 6 to kill a political opponent. So they were asking for something that was incredibly far-reaching here.
They were, and they were also making a kind of bizarre argument that you couldn't criminally indict a president for anything that the president hadn't been impeached and convicted for. And the Supreme Court said, no, that's stupid. But that was like such a far-reaching argument. Justice Sotomayor says, the majority is pretending like it's choosing some middle position because they're rejecting Trump's insane argument. But really, they've gone 99% of the way towards Trump's position.
Yeah, I mean, John Roberts, who wrote the majority opinion here, he talked about, I'm rejecting the most extreme things that Trump's lawyers argued here. But I guess what you're saying is there's so much that he agrees with that in some ways that doesn't matter.
Exactly.
The ruling was 6-3, split pretty much down ideological lines, with Roberts writing for the majority. Is that division surprising to you?
So the opinion was 6-3. And in some ways, this is unsurprising, right? The Democratic appointed justices on one side, the Republican-appointed justices on the other side. But in prior cases, before this year, when the court had to address really difficult issues, it strove to be unanimous. In cases involving Richard Nixon, for example, the court was unanimous. There was an attempt to kind of speak with one voice. We don't have that anymore. This division, I think, shows that, there are some gaps now that are unbridgeable, even at the Supreme Court that has tried in the past in these high temperature political cases to be above politics.
This ruling seems to assert that there are two kinds of presidential immunity, absolute immunity and something the court calls presumptive immunity. Can you just start by explaining what absolute immunity is, according to the court?
Well, let's just talk about what absolute immunity means generally. The idea is you can't be sued no matter what you do. So you're a judge and you issue a judicial ruling. You cannot be sued for that ruling. There's absolute immunity for that. Even if there are, claims that, you did so corruptly or whatever, you can't be sued. Absolute immunity.
According to the Supreme Court, absolute immunity is what a president gets for official acts that are part of their core constitutional powers. But the justices also went a step further by giving presidents something called presumptive immunity for duties that fall within the outer perimeter of their official responsibility.
We're going to give very broad protection, and we're going to say there's this presumption that whenever the president is acting in what looks like it could be an official capacity, there's a presumption. That is the big thumb on the scale favoring a finding of immunity. And it's the prosecutor's job to overcome that.
And the absolute immunity applies in official business, and the presumptive immunity, is that for things that are sort of on the edge of official business?
Right. So the closer you come to something that's in the Constitution, like appointing ambassadors, power of the president, the broader the immunity. And maybe there's somewhat less immunity when you're speaking to the public, since that is something that is not listed in the Constitution as one of the president's jobs. But it's still very broad immunity.
Justice Sotomayor in her dissent kind of lays out why all of this, the division between absolute immunity, presumptive immunity, official acts, all that stuff could pose problems. She gives this example like, what if a president says in an official speech he's going to stop a political rival from passing legislation he opposes? Then he hires a private hitman to murder that political rival. The speech is an official act. The hitman is an unofficial act. And, because we've created all of these distinctions, and actually the majority of justices even said that those official acts can't be used as evidence when you're talking about an unofficial act. It means like you wouldn't be able to say like, oh, listen, he made this speech, he's threatening his rival, and then he hired the private hitman. It just creates this evidentiary problem.
Yeah, we have a similar issue when members of Congress are prosecuted for bribery. There's something in the Constitution called the speech or debate clause, and it gives a kind of immunity to legislators when they do things on the floor of the Senate. And it's created some real headaches. So there would be similar issues. I think that of all the things that Justice Sotomayor says, that one bothers me less than some of the other things. The point, that's about what evidence comes in when you've got this wholly private act. I'm more worried about, if the president orders SEAL Team 6 as commander-in-chief to assassinate a rival.
Yeah, Sonia Sotomayor was the only person to bring that example up, which was so interesting to me because it was in every article you read about the hearings. The writer brought up the fact that President Trump's lawyers had said, SEAL Team 6 could assassinate a political rival. No big deal. And the only person who brought it up in the end in the decision was Justice Sotomayor in her dissent, basically saying, immune. All of these acts, you would be immune for them.
Well, what struck me in reading this majority opinion in Trump versus United States is the same thing that struck me when I read the Trump v. Anderson, which was the case involving Colorado trying to remove Trump from the ballot for engaging in insurrection. The majority, there's not a word of condemnation of what happened on January 6th or before. It's as if The court is worried about what's going to happen to the presidency in 2072. And it's not focused on what's happening right now with the threats to our democracy. I mean, that's really the headline. Justice Gorsuch, at the oral argument in the Trump versus United States immunity case, said, "We're writing an opinion for the ages." So here are these justices thinking, we're writing for posterity. And I'm thinking, you need to write for today. We've got a 5-alarm fire going on, and you're worried about what's going to happen if there's a fire in 50 years.
I mean, to be fair here, John Roberts, he takes issue with the liberals' interpretation of what he's written here. He says the dissents from Sotomayor and others strike a tone of chilling doom that is wholly disproportionate to what the court actually does today. What do you think of that?
I think this is vintage John Roberts.
Why?
When John Roberts killed off a key part of the Voting Rights Act in 2013 in the case called Shelby County versus Holder, he says, "Oh, no big deal. We're not saying that this part of the Voting Rights Act is unconstitutional. We're saying that you've got to come up Congress with a new formula. And there are lots of other ways to protect voting rights." And of course, he knew that Congress was too deadlocked to come up with a new formula, and that these other ways to protect voting rights were going to be whittled away as it has happened over the next decade. So here's Roberts, vintage Roberts's downplay, claim that he's a minimalist. This is not a minimalist decision. This is a hugely maximalist decision.
I mean, in his opinion, John Roberts talks about how with one person in charge of the whole executive branch, they need to not be afraid of being criminally prosecuted for the decisions they make. Does he have any point here that, like, this is a vital protection for someone in the executive office?
Well, I think Justice Sotomayor has a good response to that when she says that if someone tried to bring bogus charges against a president who has just left office, they'd be quickly dismissed because there'd be no basis to them. The majority says, we can't count on the good faith of prosecutors. I really think that more than anything else, aside from the fact that some of the justices might be simply trying to protect Donald Trump, they believe in this danger of, a new normal where criminal prosecutions against former presidents are going to become a regular occurrence.
Which brings us back to Jack Smith and his prosecution of Donald Trump. What's officially immune and what isn't? The court said it was not looking to rule on the specific charges here and whether they fall under official or unofficial acts. Except, Rick says, there are 3 big parts of Jack Smith's case that got explicitly name-dropped by the court.
One thing, talking to your attorney general. Remember, one of the claims was he was talking to Jeff Clark to try to overturn the results, get some fake reports of fraud from Georgia. Totally immune. That's for sure. Can't even talk about it. Number 2, talking to your vice president to try and get him to throw out some electoral votes. There's a chance that some of that might not be official, but it's probably official. And then what about the idea of whipping up the crowd on January 6th? Well, most of your public statements, you're the bully pulpit. That's your commander in chief. This is part of your job. So almost all of your official statements, that's official.
What goes on now? A lot of the decisions about what can be prosecuted here, my understanding is they go back to lower courts.
This is going to go back to eventually to the trial court. Now, one of 2 things happen after that. Number 1, Trump becomes president. His DOJ drops the prosecution. Case over. Number 2, Trump doesn't become president. And this case chugs along for another few years before we see if there'll be a trial.
Years.
Yeah, the wheels of justice turn slowly.
So Trump is also involved in other criminal prosecutions, not just this January 6th case. Does this ruling impact those at all?
Well, so let's take the hush money case. Actions before he was president.
The New York case.
I mean, he may try to argue that there's some basis to claim immunity now. That's something you'd have to argue on appeal. I think that's extremely unlikely to be successful. In the other 2 cases, he could well argue immunity. One is the Georgia election subversion case. And if Trump is immune in federal court, he's also immune in state court. And so there's going to have to be some parsing of the actions he engaged in there. And that's going to take some time. That case is already on hold because of issues related to the prosecutor there and her relationship with the special prosecutor who was appointed. And then there is the slow-walking classified documents case where the judge there in Florida is willing to entertain every kind of cockamamie argument that might help Trump. And so for sure, there's going to be a determination about whether there were some official acts involved in that case.
Listening to you, I'm just reminded of that phrase, you give someone a whole lot of rope to hang themselves with. Like, it just feels like there's just a whole lot more work to do now and paperwork to file. And while, some of these, like you said, the New York case, that's for actions before he was president, this doesn't apply. But this really does impact most of the prosecutions against Donald Trump.
Even more importantly, it would affect Trump's second term in office. Because now, remember that line from Trump about I could go down Fifth Avenue and shoot anyone and wouldn't make a difference? It's not quite that bad, but it's pretty darn bad.
We'll be back after a quick break. This show is brought to you by Discover. Have you heard about Doublenomics? It's okay if you haven't. It's extremely niche and practiced by Discover. Here's an example. Discover automatically doubles the cash back earned on your credit card at the end of your first year with Cashback Match. That means with Discover, you could turn $150 cash back into $300. It pays to Discover. See terms at discover.com/creditcard. This episode is brought to you by SAP. First, the bad news. SAP Business AI will not help you generate cubist versions of your family's holiday photos, but it will help you understand which supplier is best to help you roll out your plant-based packaging in Southeast Asia, or identify the training your junior project manager needs to rise up the ranks, or automate repetitive tasks while you focus on big innovations. So you can be ready for the next opportunity. Revolutionary technology, real-world results. That's SAP Business AI. Earlier this year, you wrote a piece for Slate with the headline, "It's past time to quit hoping the courts are going to stop Trump." Was this week like the final nail in the coffin for the courts will save us argument? The idea that the law would somehow deal with Trump?
Yeah, I mean, for me, that was a piece I wrote with Dahlia Lithwick. For me, I think that the writing's been on the wall for some time. It reminds me of that old Monty Python movie where the guy gets all his limbs cut off and he says, it's just a flesh wound. It's
yeah.
At some point, you have to realize that if the courts are not in the tank for Donald Trump, the Supreme Court has done everything it could to make it harder.
I mean, Representative Alexandria Ocasio-Cortez tweeted shortly after the verdict that she was interested in filing articles of impeachment when it comes to the Supreme Court justices upon her return to Washington. Do you think a decision like this could have actual ramifications? There's been so much talk about court reform, but the court has been pretty resistant to that so far.
Yeah, I don't think this is going to be the basis for any kind of impeachment action against the justices. It could be the basis politically for people on the left to see the Supreme Court in a more partisan way. That eventually could lead to political action, such as putting more justices on the court or limiting their jurisdiction or something. But impeachment is a very high bar. You've got a Republican House. There's no impeachment coming of any justice. And if the justices are not going to be impeached for their personal conduct, as we saw with Clarence Thomas taking all of these gifts and these trips, they're not going to be impeached for a ruling that is, even if you disagree with it, is still the judges doing law. It's not the judges being corrupt in some personally venal way.
To me, looking at this final day of the Supreme Court term, I'm struck by the fact that this immunity decision seems to fit into something broader that's going on. which I would call a realignment of power. I wonder if you think that's worth talking about, because there have been a few big decisions here right at the end that, protect the president a lot, that take away power from regulatory agencies. And I wonder if you think it's worth talking about these things together, just for a broader understanding of the project the court is undertaking here.
Well, the court has shifted power mostly to itself. And a lot of those rulings on the power of agencies it's made the bureaucratic state harder to run. There's actually a tension there, right? So the president is the one who appoints the head of most agencies, and it's the agencies that do the president's bidding. Now the courts get to second guess all of that. There's not going to be deference when agencies offer their interpretations of statutes. That's going to be more in the hands of courts. And there are going to have to be more trials. There's not going to be these administrative proceedings where agencies like the Securities and Exchange Commission go after people committing frauds. It's going to be, the agencies are going to have less power, but the president as a person ends up with more power. So it's this, kind of will empower the president, but not the president's agenda. And that's a kind of ruling that can work well if you want powerful Republican presidents, because then you could just agree with their statutory interpretations. If you have a deregulatory view of things as a judge, then you let the agency do what it wants to do, but you hamstring when the more progressive administrations are in power.
For Americans who are alarmed by these kinds of shifts, is there something they can do? I mean, I know there's the old chestnut to go vote, but it feels insufficient, I must say, when we don't get to elect Supreme Court justices.
Right. Well, in order to put a check on the Supreme Court, you need to have a Congress and a president who are willing to do that. So, I don't know in the short term what there is, but what I would say is that we haven't reached the bottom, and people who think it can't get any worse have a failure of imagination. Donald Trump is, I would say, if you want to have a stress test, see how things work, let's take the presidency out for a spin and see what this baby can do. He's the one to do it. So if he gets back into office, we'll see what the limits are of this opinion.
Rick Hasen, I'm really grateful for your insight and your time. Thanks for coming on the show.
Sorry to be such a bummer. Maybe we could talk about something else next time.
Rick Hasen writes for Slate, and he's a law professor at UCLA. He also directs UCLA Law's Safeguarding Democracy project. And that's our show. What Next is produced by Paige Osburn, Elena Schwartz, Rob Gunther, Madeline Ducharme, and Anna Phillips. We are led by Alicia Montgomery with a little boost from Susan Matthews. Ben Richmond is the Senior Director of Podcast Operations here at Slate. And I'm Mary Harris. Thanks for listening. Catch you back here next time.